Hello and welcome everyone to the Drishti IAS English YouTube channel. I'm Pragya with you today. In our today's episode of Target UPSC Prelims 2024 MCQs Practice Series, we'll be discussing the MCQs from the subject of Polity, Set 4. So let us begin our session today. The first question of our session is, consider the following statements. Your statement number 1 is, any question regarding the disqualification arising out of defection is to be decided by the speaker. So where is this anti-defection provision mentioned in our Indian Constitution? It is mentioned under the 10th schedule. Your statement number 2 is, after the 𝐏𝐤𝐄 𝐏𝐫𝐤𝐿 case 1992, the Supreme Court declared that the decision of the presiding officer cannot be questioned in any court. Your statement number 3 is, the decision of the speaker in all parliamentary matters, including disqualification issues under the 10th schedule, is final and binding. How many of the statements given above are correct? Your option A is only 1, option B is only 2. Option C is all 3 and option D is none of the above. So your correct answer is going to be option B. Only 2 statements are correct. So if we'll talk about the constitutional provisions related to speaker. So articles 93 and 178 of the Indian Constitution talks about the appointment of speaker and deputy speaker of Lok Sabha as well as the state legislative assembly. Then articles 94 and 179 deal with the vacation, resignation, removal of the offices of speaker and deputy speaker of the Lok Sabha and the state legislative assembly. Then articles 95 and 180 deals with the power of the deputy speaker or other persons to perform the duties of the office of or to act as the speaker of the Lok Sabha or the state legislative assembly. Then articles 96, 181 deal with the speaker of the or the deputy speaker not to preside while a resolution for his removal from office is under consideration. Then articles 97 and 186 deal with the salaries and allowances of the speaker and the deputy speaker. Now let us ponder upon the role of the speaker under our Indian Constitution. So the sole representative and guardian of powers and privileges of the members, the House as a whole and its committees, is the speaker. He is the principal spokesperson of the House and represents the collective voice of the House. Any question regarding disqualification arising out of defection is to be decided by the speaker, and that is why your statement number 1 is correct. His or her decision in all parliamentary matters, including disqualifications matter under the 10th schedule, is final, binding and ordinarily cannot be challenged in the court of law. Thereby, the speaker acts as the ultimate arbitrator. For example, on this question whether a bill is a money bill or not, the decision of the speaker is final. Hence, your statement number 3 is also correct. However, on the question of disqualification of the members, the Honorable Supreme Court in the 𝐏𝐤𝐄 𝐏𝐫𝐤𝐿 vs. 𝐸𝐻𝐒𝐢 and others 1992 case ruled that the decision of the speaker in this regard is subject to judicial review, and that is why your statement number 2 is not correct. Apart from this, the speaker maintains order and decorum in the House for conducting its business and regulating its proceedings. He also allocates duration for debates, can discipline members of the House and even override decisions taken by the committees of the Houses. Now let us discuss another question of our today's discussion. So your question number 2 is, which one of the following is not a power of the Lok Sabha? So your statement A is makes laws on matters including in the union and concurrent lists. Then your statement number B is can introduce and enact money and non-money bills. Your statement number C is can initiate procedure for removal of Vice President of India. Your statement number D is amends the Constitution of India. So it is asking which of the following is not a power of the Lok Sabha. Definitely your answer is going to be option C. The Lok Sabha is not empowered to initiate the procedure for removal of Vice President of India. The Constitution of India divides legislative authority on various subjects between the union and the states in 3 lists such as the union list, state list and concurrent list. And these lists are mentioned under the 7th schedule of our Indian Constitution. The 2 houses of the Parliament, Lok Sabha and Rajya Sabha, have exclusive authority to frame laws on subjects enumerated in the Union list. These includes foreign affairs, defence, armed forces, communication posts and telegraphs, foreign trade, etc. Whereas in the case of concurrent list, criminal and civil procedure, marriage and divorce, economic and special planning, trade unions, electricity, newspapers, books, education, population control, family planning, etc. Both the Parliament and the state legislatures have the power to legislate. In case of money bills under Article 110 of our Indian Constitution, it can only be introduced in the Lok Sabha and not in the Rajya Sabha, whereas non-money bills can be introduced in either house of the Parliament, that is the Lok Sabha or the Rajya Sabha. The Rajya Sabha alone can initiate the removal of Vice President of India, because Vice President of India is the ex officio chairman of the Rajya Sabha, and that is why only Rajya Sabha is empowered to initiate the procedure of his removal. A Vice President may be removed from his office by a resolution of the Council of States passed by a majority of all the then members of the Council and agreed to by the House of the People. The Constitution vests in the Parliament the power to amend the Constitution. Constitution amendment bills can be introduced in either house of the Parliament, while motions for introduction of a constitutional amendment bills are adopted by simple majority. A majority of the total membership of the House and a majority of not less than 2/3 of the members present and voting is required for adoption of effective clauses and motions for consideration and passing of these bills, and that is why your statement number 1A is also correct, B is also correct and D is also correct. However, your statement number C is incorrect in nature. Now let us discuss another question of our today's discussion. So the question is with reference to the representation of Anglo-Indian community, consider the following statements. Your statement number 1 is the President can nominate 2 members from the Anglo-Indian community in the Lok Sabha if they are not adequately represented. Your statement number 2 is the Governor of a state can nominate 1 member from the Anglo-Indian community in the State Legislative Assembly. Which of these statements given above are correct? Your option A is 1 only, option B is 2 only, option C is both 1 and 2 and option D is neither 1 nor 2. So the correct answer for this question will be option D, neither 1 nor 2. That means both of these statements are incorrect in nature. Under Article 366 Clause 2 of our Indian Constitution, an Anglo-Indian is a person whose father or any of whose other male progenitors in the male line was of European descent but who is domiciled within the territory of India and was born within such territory of parents habitually resident therein and not established there for temporary purposes only. The 104th Constitutional Amendment Act passed by the Parliament has done away with the reservation for Anglo-Indian members altogether under Article 331 and Article 333 of our Indian Constitution. Article 331 dealt with the power of the President to nominate 2 members from the Anglo-Indian community to the Lok Sabha, and Article 333 dealt with the power of the Governor to nominate 1 member from the Anglo-Indian community in the legislative assemblies of the state. The reservations for Anglo-Indians in the form of nomination expired on 25th January 2020, as the Amendment Act does not extend the facility of reservation to the community. So, by the 104th Constitutional Amendment Act, the representation of the Anglo-Indian community through way of nomination, or you can say through way of reservation, has expired. Moving to the next question of our today's discussion. So, the question is, consider the following statements regarding the relation between the office of governor and the central government. Your statement number 1 is, the governor is the nominee of the central government. Your statement number 2 is, the office of governor is an employment under the central government. Your statement number 3 is, the governor can be removed only on the grounds mentioned in the Constitution. How many of the statements given above are correct? Your option A is only 1. Your option B is only 2. Your option C is all these 3 statements are correct, and your option D is none of these statements are correct. So, a correct answer is going to be option A. That is, only 1 of these statements are correct. The Constitution of India provides that there shall be a governor for each state, and the executive powers of the state. Executive power of the state shall be vested in the governor, who would exercise them either himself or through officers subordinate to him. Article 155 of our Indian Constitution lays down that the governor of a state is appointed by the president by warrant under his hand and seal, which means that the governor is a nominee of the central government, and that is why your statement number 1 is correct in nature. Though appointed by the president, that is the central government, the governor is not in the employment under the government of India. It has been held by the Honorable Supreme Court of India that the office of the governor is subordinate to the government of India, and that is why your statement number 2 is incorrect in nature. Article 156 of our Indian Constitution provides that the governor holds office during the pleasure of the president. The grounds on which a governor may be removed are not laid down in our Indian Constitution. Therefore, the president can remove the governor from office at any time without assigning any reason and without giving any opportunity to show cause. You remember that this is a deviance from the impeachment procedure of president and the governor. If you want to remove the president, a 14 days notice period is required, and the president also has the power of representation. But this is not the case in the case of governor. He is completely dependent on the pleasure of the president, his appointment also and his removal also. Further, as held in the BP Singhal versus Union of India, though no reason need to be assigned for discontinuance of the pleasure, Article 156 Clause 1 cannot be exercised in an arbitrary, capricious or unreasonable manner. So, your correct answer is only 1 statement here is correct. Moving to the next question of our today's discussion. So, the question is, the governor of a state does not have constitutional discretion in which of the following cases? Your option A is reservation of a bill for the consideration of the president. Your option B is appointment of a chief minister when no party has a clear-cut majority. Your option number C is recommendation for the imposition of president's rule in the state. Your option D is seeking information from the chief minister regarding the administrative and legislative matters of the state. So your correct answer is going to be option B, appointment of a chief minister when no party has a clear-cut majority. So under Article 163 of our Indian Constitution, the governor exercises his power and function on the aid and advice of the Council of Ministers headed by the Chief Minister. However, there are constitutional discretion, express discretions that are mentioned in our Indian Constitution of a governor in the following cases. These cases include reservation of a bill for the consideration of the President, recommendation for the imposition of President's rule in the state, while exercising the functions as the administrator of an adjoining union territory, determining the amount payable by the government of Assam, Meghalaya, Tripura and Mizoram to an autonomous tribal district council as royalty accruing from licenses for mineral exploration, seeking information from the chief minister regarding the administrative and legislative matters of the state, appointment of a chief minister when no party has a clear-cut majority in the state legislature, or when the chief minister in office dies suddenly and there is no obvious successor, is a case in which the governor has situational discretion and not constitutional discretion. So kindly remember this point, that no, it is not a constitutional discretion, it is rather a situational discretion. Whether a matter falls within the governor discretions or not is to be decided by the governor, and his decision in this regard is final in nature, and therefore your option B is the correct answer for this question. Moving towards the next question of our today's discussion. So your question is, consider the following statements regarding the legislative powers of the governor. Your statement number 1 is, the Constitution authorizes the governor to summon, dissolve and prorogue the state legislative assembly. Your statement number 2 is, the governor exercises the power to summon the state legislative assembly on the aid and advice of the Council of Ministers. Your statement number 3 is, the power to summon the House is not solely vested in the governor and should be exercised with the aid and advice of the Council of Ministers and not at his own. How many of the statements given above are correct? Your option A is only 1, your option B is only 2, your option C is all 3 and your option D is none of the above. So your correct answer for this question is going to be option C. All of these 3 statements are correct in nature. Article 174 of the Indian Constitution authorizes the governor to summon, dissolve and prorogue the state legislative assembly, and hence your statement number 1 is correct. The governor exercises the above powers under Article 163 of our Indian Constitution, which says that the governor acts on the aid and advice of the Council of Ministers headed by the Chief Minister, and that is why your statement number 2 is also correct. Further, in 2016, the Supreme Court in Namam Rebia and Bamang Felix versus Deputy Speaker case, the Arunachal Pradesh Assembly case, said that the power to summon the House is not solely vested in the governor and should be exercised with the aid and advice of Council of Ministers and not his own discretion, and that is why your statement number 3 is also correct. Now let us discuss another question of our today's discussion. So the question is, with reference to the parliamentary system of governance provided by the Constitution, consider the following statements. Your statement number 1 is, the Chief Minister is the de jure executive head of the state. And your statement number 2 is, the governor is the de facto executive head of the state. Which of these statements given above are correct? Your option A is 1 only. Your option B is 2 only. Your option C is both 1 and 2. And your option D is neither 1 nor 2. That means both of these statements are incorrect in the nature. So a correct answer is going to be option D. Neither 1 nor 2 statements are correct. That means both of these statements are incorrect in nature. The Constitution provides that there shall be a governor for each state and the executive powers of the state shall be vested in the governor, who would exercise them either himself or through officers subordinate to him. He is the de jure executive head of the state. Not the de facto executive head, rather he is the de jure executive head of the state. And that is why your statement number 2 is incorrect in nature. Though the chief minister and his ministers hold during the pleasure of the governor, a governor exercises his executive power with the aid and advice of the council of ministers headed by the chief minister. In the parliamentary system of governance, a chief minister is the elected head of the state government. That means he is the de facto executive head of the state. And that is why your statement number 1 is incorrect in nature. The real executive authority rests with the chief minister in the case of the state government. Now let us proceed to another question of our today's discussion. So your question is, with reference to the state executive, consider the following statements. Your statement number 1 is, the constitution provides for specific procedure for the selection and appointment of the chief minister under article 164. Your statement number 2 is, as per the conventions of the parliamentary system of government, the governor has to appoint the leader of the majority party in the state legislative assembly as the chief minister. Your statement number 3 is, the governor cannot exercise his individual judgment in the selection and appointment of the chief minister under any circumstances. How many of the statements given above are correct? Your options are only 1, your option B is only 2, your option C is all 3, and your option D is none of the above. So the correct answer for this question is going to be option A. Only 1 statement is correct. The constitution does not contain any specific procedure for the selection and appointment of the chief minister. Article 164 only says that the chief minister shall be appointed by the governor. However, this does not apply that the governor is free to appoint anyone as the chief minister. In accordance with the conventions of the parliamentary system of government, the governor has to appoint the leader of the majority party in the state legislative assembly as the chief minister, and that is why your statement number 2 is correct in nature. The governor has discretion under multiple circumstances, which include the situation when no party has a clear majority in the assembly. The governor can also exercise his individual judgment in the selection and appointment of chief minister when the chief minister in office dies suddenly and there is no obvious successor, and that is why your statement number 3 is incorrect in nature, and that is why your correct answer is only 1 of the statements are correct in nature. Now proceeding to question 9 of our today's discussion. So the question is, with reference to the landmark judgment in S.R. 𝐏𝐵OMAI versus Union of India, consider the following statements. Your statement number 1 is, it laid down certain guidelines so as to prevent the misuse of Article 356 of the Indian Constitution. Your statement number 2 is, it upheld that the judicial review is the basic structure of the Indian Constitution. Your statement number 3 is, the validity of a proclamation of President's rule is subject to the judicial review. Your statement number 4 is, it upheld that federalism is the basic structure of our Indian Constitution. How many of the statements given above are correct? Your option A is only 1, your option B is only 2, your option C is only 3, and your option D is all of the above statements given above are correct. So your correct answer is going to be option C. Only 3 statements are correct. S.R. 𝐏𝐵OMAI versus Union of India was a landmark judgment of the Supreme Court of India, where the court discussed at length provisions of Article 356 of the Constitution of India and related issue. Let me know in the comment box below, what does Article 356 of the Constitution deals with. The 𝐏𝐵OMAI case verdict laid down the conditions under which the state governments may be dismissed and mechanisms for that process, and therefore your statement number 1 is correct. The verdict concluded that the power of president to dismiss a state government is not absolute in nature. The verdict said that the president should exercise the power only after his proclamation imposing his or her rule in a state is approved by both the houses of parliament. So, it should be approved by both the houses of the parliament. Till then, the president can only suspend the legislative assembly by suspending the provisions of constitution relating to the legislative assembly. The case put an end to the arbitrary dismissal of state governments by a hostile central government and upheld that the proclamation of president's rule is subject to judicial review. And that is why your statement number 3 is correct in nature. The action of the president, if found irrelevant, malified, perverse, can be struck down by the Honorable Supreme Court of India. The judgment categorically ruled that the floor of the assembly is the only forum that should test the majority of the government of the day and not the subjective opinion of the governor, who is often referred to as the agent of the central government. The court laid down a number of guidelines to curb the centre's capacity to dismiss a state government and upheld that the federalism is the basic structure of the Indian Constitution. Hence, your statement number 4 is also correct. Judicial review as the basic structure of the Indian Constitution was upheld by the Honorable Supreme Court of India in the judgment of 𝐈𝐀𝐒 𝐏𝐫𝐞𝐥𝐬 versus State of Tamil Nadu, also known as the 9th schedule case. And that is why your statement number 2 is incorrect. So, the correct answer for this question is only 3 statements are correct. Now, let us discuss question number 10 of our today's discussion. So, the question is, consider the following statements. Your statement number 1 is, the total number of ministers excluding the chief minister shall not exceed 15% of the total strength of the legislative assembly of that state. Your statement number 2 is, the advice rendered by ministers to the governor cannot be inquired in any court. Your statement number 3 is, the constitution provides that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha, there shall be one ministry for the tribal welfare. How many of the statements given above are correct? Your options are, option A is only 1, option B is only 2, your statement number 3 is all 3, and your statement option D is none of the above. So, your correct answer is going to be option B. Only 2 of these statements are correct in nature. The chief minister is appointed by the governor and the council of ministers are appointed by the governor on the advice of the chief minister. The constitution under article 164 provides that the total number of ministers, including the chief minister, in the council of ministers of a state shall not exceed 15% of the total strength of the legislative assembly of that state. However, as per the 94th Constitutional Amendment Act 2006, the number of ministers in the council of ministers, including the chief minister, shall not be less than 12. Shall not be less than 12, and that is why your statement number 1 is incorrect in nature. Under article 163, the advice rendered by the council of ministers to the governor is or cannot be inquired in any court of law, and that is why your statement number 2 is correct in nature. Constitution under article 164 provides that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha, there shall be a minister in charge for tribal welfare, and that is why your statement number 3 is also correct, and hence the correct answer for this question is going to be option B. Only 2 statements are correct. Now let us discuss a practice question of our today's discussion. So the question is, consider the following statements. Your statement number 1 is, in appointment of the chief secretary in a state, consultation of the central government is binding. Your statement number 2 is, the tenure of the chief secretary is 3 years fixed by the Constitution of India. Which of the statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. And this answer will be given by you to me in the comment box below. With this, we come to a conclusion of our today's discussion. I hope this session was insightful for you. If you liked the today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.